Riya's complaint has reached the platform. The fake account is reported, the altered image is identified, the fraudulent payment link is preserved. Then the case changes. The same link appears in 3 states. Investigators suspect an organised campaign, and the university's network detects malicious traffic connected to the same infrastructure. Now 4 officials ask 4 different questions. Can investigators obtain specified communications? Can the malicious page be blocked from public access? Can a cybersecurity agency study the traffic surrounding the attack? And can CERT-In demand logs and incident information? It is tempting to call all 4 actions surveillance or government control. But that would hide the law. These are 4 distinct powers. They target different things, rest on different grounds, and follow different procedures. This is beyond bare act, where we separate a legal power from the safeguards that make its use lawful. This topic is not only about spies, encrypted phones, or dramatic national security cases. It can arise during an ordinary criminal investigation. It can affect a social media post, a phishing page, a company under cyber attack, a university network, or a person whose private messages are sought. And the most important question is rarely just, does the government have power? A serious legal analysis asks 7 things. Who acted, what was targeted, which ground was used, whether reasons were recorded, which procedure applied, how long the action may last, and who can review it. By the end of this episode, you will be able to separate interception, blocking, traffic data monitoring, and incident response, and apply the correct legal test to each. Start with the object of the proposed action. Section 69 concerns information generated, transmitted, received, or stored in a computer resource. It can authorise interception, monitoring, or decryption. Section 69A is different. Its immediate result is to block public access to identified online information. Section 69B concerns traffic data or information for a defined cybersecurity purpose, enhancing cybersecurity and identifying, analysing or preventing intrusion or the spread of a computer contaminant. Section 70B establishes CERT-In as India's national agency for cybersecurity incident response. It may call for information and issue directions for that role. Think of it this way. Section 69 asks, may the state lawfully access or make intelligible specified information? Section 69 A asks, may the public route to identified information be blocked? Section 69B asks, may authorised cyber defenders analyse the traffic surrounding a threat? Section 70B asks, what must be reported or supplied so that the incident can be handled? One event may activate more than one provision, but every action needs its own legal foundation. None of these powers operates outside the Constitution. Interception can affect privacy under Article 21 and expression under Article 19. Blocking directly affects expression and may also affect trade carried on through the Internet. Article 14 requires state action to be non-arbitrary. In Justice K.S. Puttaswamy, the Supreme Court recognised privacy as a fundamental right. For our purpose, the decision supplies a disciplined test. Is there a law? Does the action pursue a legitimate state aim? Is the measure rationally connected to that aim? Is a less restrictive but equally effective measure reasonably available? And are the impact and safeguards proportionate to the objective? Proportionality does not mean the state can never act. It means power must be justified, tailored and reviewable. Section 69 empowers the central government, a state government, or a specially authorised officer of the appropriate government. The authority must be satisfied that interception, monitoring or decryption is necessary or expedient on at least one statutory ground. Those grounds include sovereignty or integrity of India, defence of India, security of the state, friendly relations with foreign states, public order, preventing incitement to a cognizable offence relating to those grounds, and, importantly, the investigation of any offence. That final ground means Section 69 is not confined to terrorism or national security. It may arise in an ordinary offence investigation. But the existence of an investigation does not remove the safeguards. Reasons must be recorded in writing, and the Act must be read with the 2009 interception, monitoring and decryption rules. Interception is broader than listening to a live telephone call. In the digital rules, it can include acquiring, viewing, inspecting, or diverting content so that it becomes available beyond the intended sender or recipient. Monitoring includes viewing, listening to, or recording information through a monitoring device. Decryption means converting encrypted information into an intelligible form. So the subject may be an email in transit, a direct message, a cloud file, or information already stored in a computer resource. But an informal police email is not automatically a Section 69 order. Legal authority, written reasons, and the prescribed route still matter. Under the 2009 rules, the ordinary competent authority is the Union Home Secretary for the central government and the Secretary in charge of the Home Department for a state or union territory. The rules permit narrow exceptions for unavoidable circumstances and operational emergencies, but emergency is not a blank cheque. Where the special emergency route is used, the competent authority must be informed in writing within 3 working days, and approval must be obtained within 7 working days. Without approval, the activity must stop. The order must state reasons. A copy must reach the review committee within 7 working days. Before issuing it, the authority must consider whether the information can reasonably be obtained by another means. The direction must also be specific. It may identify a person or class of persons, a particular subject, one or more computer resources, or specified premises. It must identify the authorised agency officer who will receive the information. Ordinarily, an order lasts no more than 60 days. It may be renewed, but the total cannot exceed 180 days. Those are maximum limits, not automatic entitlements. Necessity must continue throughout the period. The review committee meets at least once every 2 months. If it finds that an order does not comply with Section 69, it can set the direction aside and require destruction of the material and its copies. Retention is not indefinite. Authorised agencies ordinarily destroy interception records every 6 months unless the material is still required for functional needs. An intermediary ordinarily destroys direction-related records within 2 months after discontinuance, unless an investigation, complaint, or legal proceeding requires them. Section 69 can require a subscriber, intermediary, or person in charge of the computer resource to provide specified technical assistance. Failure to assist under subsection 3 can attract imprisonment up to 7 years and a fine. But a legal direction does not manufacture a key that nobody holds. Under the 2009 rules, a decryption direction may be addressed to the holder of the decryption key. For an intermediary, the direction is limited to the extent that the intermediary encrypted the information or controls the key. Imagine an end-to-end encrypted service. It may possess subscriber details, delivery records, or an encrypted payload, yet not possess the plain text of a message. A careful lawyer therefore asks 2 separate questions. What does the lawful order require? And what can this recipient technically provide? Decrypt it is not a complete legal or technical analysis. 3 Supreme Court decisions supply the constitutional background. First, People's Union for Civil Liberties versus Union of India. The case concerned telephone tapping under the Telegraph Act. The court treated tapping as a serious invasion of privacy and laid down procedural safeguards until rules were framed. Its lasting lesson is simple. Intrusive power needs lawful authority and protection against arbitrary use. Second, Puttaswamy. It places privacy on a constitutional foundation and requires legality, legitimate aim, proportionality, and fair procedure. Third, the Pegasus proceedings, Manohar Lal Sharma versus Principal Secretary. The Supreme Court did not make a final finding that the alleged spyware use had been proved. It appointed an independent technical committee to investigate. It also made an important institutional point. Merely invoking national security does not automatically exclude judicial review. Teach the cases for what they decided, not for claims they did not decide. Now move from accessing information to restricting access to it. Section 69A empowers the central government or an officer specially authorised by it to direct a government agency or intermediary to block public access to online information. Unlike Section 69, the provision does not give the same power to a state government in its own right. The listed grounds are sovereignty and integrity of India, defence of India, security of the state, friendly relations with foreign states, public order, and preventing incitement to a cognizable offence relating to those grounds. Notice what is missing. Section 69A does not contain Section 69's separate ground of investigation of any offence. It is therefore not a universal remedy for every fraudulent, defamatory, or unlawful post. The central government must consider blocking necessary or expedient on a listed ground and record reasons in writing. Failure by an intermediary to comply with a lawful direction may attract imprisonment up to 7 years and a fine. And remember the legal effect. A blocking order restricts public access. It does not, by itself, prove that the information was false. The ordinary procedure comes from the 2009 blocking rules. A request travels through the nodal officer of an authorised government organisation to the central government's designated officer. The designated officer places the request and a sample of the information before a committee. Reasonable efforts must be made to identify the originator or intermediary. Where identified, the person or intermediary receives notice and at least 48 hours to appear and respond. The committee examines whether the request falls within Section 69A and whether blocking is justified. It makes a specific written recommendation. Final approval rests with the Secretary, MEITY. The ordinary request is to be decided expeditiously and, under the rules, no later than 7 working days after receipt from the nodal officer. The rules also contain an emergency route. If delay is unacceptable, the Secretary may approve interim blocking without a prior hearing, but reasons must be recorded. Within 48 hours, the matter must go to the committee. If final approval is refused, the interim block must be revoked. A separate route operates when a competent Indian court issues an order. The review committee meets at least once every 2 months and may set aside a non-compliant direction and require unblocking. Rule 16 requires strict confidentiality about requests and action taken. Confidentiality may protect sensitive material, but it can also make a challenge difficult if the affected person cannot see the order or reasons. That tension is why reasoned records and judicial review matter. In Shreya Singhal versus Union of India, the Supreme Court struck down Section 66A, but upheld Section 69A and the blocking rules. Why the different result? The court treated Section 69A as tied to specific grounds and supported by procedural safeguards, written reasons, committee scrutiny, an opportunity to be heard where the originator or intermediary is identified, review, and the availability of a constitutional challenge. This does not mean every blocking order is automatically valid. It means the provision survived a challenge to the law itself. A particular order may still be challenged for want of authority, use of an unlisted ground, inadequate reasons, procedural failure, arbitrariness, or disproportionality. Before leaving blocking, separate 3 legal routes. First, Section 69A, central government blocking of public access on its listed grounds through the 2009 process. Second, Section 79, subsection 3, Clause B, read with the current rule 3.1. D. the actual knowledge root affecting an intermediary's safe harbour. Under the Consolidated Rules Current in August 2026, actual knowledge arises through a competent court order or a reasoned written intimation from a properly authorised government officer. The information must be specifically identified, and the current compliance period is 3 hours. This is a different legal architecture from Section 69A. Read the order before choosing the section. Third, an internet shutdown. That suspends the telecommunications service or channel in an area. It does not merely block one item of online information. The current route is Section 20 of the Telecommunications Act 2023, read with the Telecommunications Temporary Suspension of Services Rules 2024. Anuradha Bhasin was decided under the earlier Telegraph Act and 2017 rules. Its constitutional holdings remain important. Expression and trade through the Internet receive Article 19 protection. Indefinite suspension was impermissible under the then framework. Proportionality and review are required, and suspension orders must be published so they can be challenged. Use the case for those principles. Do not present the old 2017 rules as the law currently in force. Section 69B changes both the object and the purpose. The central government may, by Gazette notification, authorise a government agency to monitor and collect traffic data or information. The purpose is defined. Enhancing cybersecurity and identifying, analysing or preventing intrusion or the spread of a computer contaminant. Traffic data can include origin, destination, route, time, date, size, duration, service type, and information identifying a person, system, network or location connected with a communication. It is often called metadata. But metadata is not automatically harmless. When many records are linked, they may reveal relationships, routines, devices, and locations. At the same time, traffic analysis can expose malicious infrastructure, command and control traffic, denial of service attacks, or malware propagation. The legal discipline is purpose limitation. Section 69B is not drafted as a general power to read everyone's content or investigate every offence. The 2009 traffic data rules require the authorised route, designated officers, record keeping, secrecy and destruction safeguards. CERT-In was authorised by a 2016 central government notification for the Section 69B cybersecurity purpose. Direction-related records are ordinarily destroyed within 6 months after monitoring ends, unless they are needed for an investigation, criminal complaint or legal proceeding. Intentional or knowing failure to assist can now attract imprisonment up to 1 year or a fine up to 1 crore rupees or both. Section 70B makes CERT-In the National Agency for Cybersecurity Incident Response. Its statutory functions include collecting and analysing incident information, issuing forecasts and alerts, taking emergency measures, coordinating incident response, and publishing guidelines, advisories and vulnerability notes. To perform those functions, CERT-In may call for information and give directions to service providers, intermediaries, data centres, bodies corporate and other persons. Its directions of 28 April 2022 remain published by CERT-In as the operative cybersecurity directions. Covered entities must synchronise system clocks with specified Indian time sources or accurate sources traceable to them. Listed cyber incidents must be reported within 6 hours of being noticed or brought to notice. The deadline is for reporting, not for finishing the investigation. The FAQ permits available information to be sent first and supplemented later. Covered entities must designate a point of contact. They must enable ICT system logs, keep them securely for a rolling period of 180 days within Indian jurisdiction, and provide them with an incident report or when lawfully directed. Data centres, virtual private server providers, cloud providers, and VPN service providers have specified validated subscriber record duties generally for 5 years after cancellation or withdrawal of registration. Specified virtual asset service providers, exchanges and custodian wallet providers also have 5-year KYC and transaction record duties under the directions. Failure to provide information or comply with a Section 70B direction can attract imprisonment up to 1 year, or a fine up to 1 crore rupees, or both. One final distinction. CERT-In is not NCI-IPC. NCI-IPC under Section 70A focuses on critical information infrastructure. CERT-In's incident response role is broader and can apply even where the affected system has not been formally designated as critical infrastructure. Now apply the framework. Investigators first seek specified stored messages connected with the payment fraud. Do not jump straight to Section 69. Ask what is actually sought. Subscriber data, a preservation request, a production order, a search power and an interception direction are not identical. If Section 69 is invoked, identify the competent authority, the investigation ground, written reasons, specificity, duration and the recipient's real technical capability. Second, the central government considers blocking the malicious page. Ask whether a Section 69A ground genuinely applies. Identify the precise URL or information. Then test the ordinary, emergency or court order procedure, the reasons and the review. Fraud alone should not be used as a verbal shortcut for Section 69A. If no listed Section 69A ground exists, another lawful route may be required. Third, a notified cybersecurity agency studies the connection patterns around the university intrusion. That points to Section 69B, provided the object is traffic data and the purpose is the cybersecurity purpose written into the section. Fourth, the university discovers unauthorized access and malicious code. It must assess the CERT-In reporting list. If the incident is reportable, the 6-hour clock begins when the incident is noticed or brought to notice. Available facts go first. Investigation and supplementation continue. 4 actions, 4 routes. 1 constitutional requirement: power must remain lawful, specific, necessary and reviewable. For any exam problem, advisory note or rights challenge, use this 10-question method. 1. What exactly is being sought? Content, blocking, traffic data, logs or incident assistance. 2. Which statutory provision is written on the order? 3. Does the issuing actor possess that power? 4. Which statutory ground or purpose is relied upon? 5. Are the reasons written and the target specific? 6. Was notice required, given, or lawfully postponed in an emergency? 7. Were less intrusive alternatives considered? 8. What duration, retention and destruction limits apply? 9. What can the recipient technically provide? 10. Which executive and judicial review mechanisms are available? If you answer those questions in order, the problem stops looking like one enormous surveillance issue. It becomes a series of propositions that can be proved or challenged. The IT Act gives the state significant digital powers. But the government can act is never the end of the legal analysis. Section 69 concerns interception, monitoring and decryption. Section 69A concerns central government blocking on listed grounds. Section 69B concerns traffic data for defined cybersecurity purposes. Section 70B equips CERT-In to coordinate incident response. The rule to remember is simple. Classify the object, identify the legal route, and test the safeguards. In Episode 8, we follow Riya's case into investigation and court. Territorial reach, search, cyber forensics, electronic evidence, and the question that decides whether a digital record can be trusted. If this episode clarified the law, subscribe to Beyond Bare Act. Here, we do not stop at the section number. We ask how the power actually works.